Great. Thank you so much, Mike. As he said, this is a tenant education workshop. My name is Marco, housing navigator at Path. Today, as folks navigate the San Diego housing market, it's really important to be aware of your rights as a tenant and make sure that, you don't face any sort of discrimination from landlords or property owners as you rent apartments, apply to properties, things like that. Um, so as Mike mentioned, we're going to save questions till the end. And our agenda today, we're going to be covering a lot. So applying to apartments, some move-in tips, some things about leases and rental agreements, rent increases, paying your rent, repairs to the unit, habitability requirements, your tenant responsibilities, the landlord responsibilities, notices, move-out tips, and security deposits. So yeah, and then at the end we'll cover some questions and answers. So we'll just go ahead and jump right in. So for applying for apartments, applications, you can't get approved for an apartment without an application. So it's a pretty pivotal step in the whole process. So once you locate a property that is interesting or worth applying to, or worth applying to, getting that application in, and what you might find is that they ask for current and prior addresses, your employment and income information, any sort of banking information, and your household size. Applications may ask for you to sign a release for credit and background checks, and landlords typically check for prior evictions and criminal history. They also typically require a debt to income ratio and a rent to income ratio. So sometimes when you're looking at apartments, you might find that in the description, it'll say you need to make, 2.5 times the rent, 2 times the rent. That's basically the landlord kind of trying to hedge their bets, saying, okay, if they make enough money, I can feel comfortable renting to them, right? So that's part of the reasoning for them to require a certain amount of income. So these are protected classes. These are things that the landlords can't ask about. So that's your race, your color, your religion, sex, sexual orientation, marital status, national origin, ancestry, familial status, disability or medical conditions, immigration or citizenship status, and then age, unless it's a 55 or older community. There's no blanket ban on all criminal convictions. So if you do have some sort of criminal background, then they'll still have to take a look at it on a case-by-case basis. And then another important thing, if you have a pet, an emotional support animal, an ESA, is an animal that provides emotional cognitive support to a person with a disability. It's different from a service animal. So an ESA animal is not required to be registered or certified as a service animal. You don't need to do all the training and certification in order for it to be an ESA. And then the important part here is that a landlord may not charge someone with an ESA a pet deposit, a pet rent, fee, or acquire liability insurance covering the animal. So that can be important, right? If you have a dog that you love that is a part of your support system, it's worthwhile to talk to your healthcare provider or a medical professional that is helping you and see if you can get an ESA letter. It can help cut some of that red tape, those barriers that might make it harder to find an available apartment, because not all apartments are pet friendly. So the only requirement is a letter from a licensed medical professional stating that your ESA is part of your treatment for a mental health condition. All right, so we're going to touch on security deposits now, and then we'll revisit them a little bit later. So everything except the application fee and the first month's rent is considered a deposit. A holding deposit may be non-refundable if a tenant changes their mind and decides not to rent. A holding deposit, many times, if you apply, they'll say include something like $100 holding deposit, meaning that they won't accept other applications for that unit. And then if you're approved and you decide to move forward with that unit, many times they will include that holding deposit as part of the security deposit. So let's say you provided $100 for a holding deposit when you originally applied, and then the security deposit is $1,500. If you're approved and you already submitted that $100 payment, then you'll only owe $1,400. And then if you decide to not go through with the not go through with renting the apartment, they may continue to they might keep the holding deposit, but if you are denied the apartment, then they will return the holding deposit, if that makes sense. A max deposit is 2 months rent for an unfurnished unit and 3 months rent for a furnished unit. And security deposit must be specified as fully refundable minus damages to the unit if applicable. So basically, if you provide that $1,500 when you first move in, then when you move out, you should receive that $1,500 again, minus any sort of deductions for any sort of damages to the property, not including normal wear and tear. Some move-in tips. So the rental agreement or lease should be in writing to avoid confusion. Get a receipt for the deposit and any amounts paid. That'll be important to make sure that there's evidence that you provided that payment. Inspect the actual unit to be rented prior to signing the agreement. Take photographs of the condition of the unit at the time of move-in, and then notify the landlord immediately in writing if there are any sort of pre-existing damages. This will make it so that, when you move out and there were some damages that were there when you first moved in, you're not going to get charged for them upon move out. Yeah. And then another thing that I want to touch on while we're talking about payments, to avoid, falling for any scams that are out there on application websites, Craigslist, things like that, make sure to not submit any payments until you've seen a unit in person and feel comfortable that you've connected with the landlord who actually has a legal right to rent the property. All right, leases and rental agreements. So rental agreements can be written or oral, but we do highly suggest that they be written for clarity and for evidence. They can be fixed term, meaning that they can be like a 12-month lease, a year-long lease, or they can be periodic, meaning they're month to month. And the rental agreement should specify the parties to the agreement, the physical address of the rental property, the term of the rental period, the amount of rent to be paid, when and where the rent is to be paid, to whom the rent is to be paid, and their contact information, who pays for the utilities, who can accept notices on behalf of the landlord, how the rent is to be paid, and the amount required for the security deposit. So those are just some of the items that are really important to have clearly stated in the lease agreement, so that there's no kind of confusion on, hey, I thought my lease lasted until June, but you're having me, move out in May, something like that. So having that kind of clarity is important. Changes to the rental agreement. If it's a fixed term lease, meaning it's something like a 12-month lease, no changes are permitted during the term unless the lease states otherwise. For month to month, the landlord has a lot more flexibility to make changes between the months, usually giving about a 30-day notice. So if there is some kind of rent increase or change to the rules that they want to rent the property for, as long as they give that 30-day notice and you want to continue renting with them, that's something that they might have the ability to do. The landlord must give written notice of change of ownership or change in management. So again, you have a right as a tenant to know what's kind of happening to the property. It's also important because if there's a change in ownership or change in management, that might change how you submit rent, how you submit complaints, how you might submit any sort of request for maintenance, stuff like that. Rent increases. So there's no rent increases during a fixed term unless the lease allows. This sometimes can be included in a low income unit, subsidized unit. Rent increases of 10% or less require a 30-day written notice, while an increase of 10% total in the last 12 months requires a 60-day notice. So a landlord can increase the rent a maximum of 2 times in a 12-month period, but it can't exceed 10% of the total rent. You're not allowed to raise the rent over 10% in a 12-month period. Paying rent. So in absence of the agreement stating rent is due in advance or on a specific date, the rent is due on or before the first of the month. Any late fee must be in writing. A late fee date is not necessarily a grace period, and you need to make sure to read your lease agreement carefully to make sure that you understand what a grace period might look like and what a late fee when a late fee might come into play. If a tenant consistently pays rent late, even after covering late fees, a landlord does have a right to ask the tenant to vacate. So this means that you still, even if you are covering, back rent or late rent, you want to make sure that you're communicating properly with the landlord so that you're not getting in trouble down the road. Landlords really value when tenants pay rent on time, so it's one of those things that once you move in, you want to prioritize. And then as a tenant, you have a right to a rent receipt if requested. A money order receipt is not proof of rent payment. So you want to be careful, just because you got a money order from, Vaughn's doesn't necessarily mean that you paid rent. You want some kind of proof provided by the property owner. If the rent agreement allows for payment by mail, the postmark is deemed the day rent was paid. So putting the rent in the mail is considered the day rent was paid. The landlords may apply the payment towards older debts unless otherwise indicated. So if you're a month behind on rent and you pay this month's rent, they might apply it to a previously owed. Hi, welcome. A previously owed rent. Repairs to the unit. The landlord owes a non-waivable duty to provide a habitable dwelling. That means you can't be, oh, I'm laid back. I don't need, all these things that are required. They are required to provide a habitable unit by law in order to rent the unit. Again, as we mentioned previously, make sure to inspect and take pictures of the unit when you move in. It's for your protection and is always useful in communication with the landlord if there's any sort of maintenance issues. The lease should state exactly how long the landlord has to respond to repair requests. And then if the repair requests affect habitability or livability, like running water or heat, the landlord is required to respond urgently. And then the definition of habitability, it's fit for occupancy by humans in substantial compliance with state and local building codes that materially affect the tenant's health and safety. Unfortunately, habitable does not mean perfect or aesthetically pleasing. So sometimes you'll find a place that is being rented and might not be your perfect idea of an apartment, but it could still meet those habitability requirements. Responsibility for repairs. Per Civil Code Section 1941, it is the landlord's responsibility, unless there's an agreement otherwise, to put the rental unit in a condition fit for human occupancy, to repair all subsequent dilapidations that render it untenable, subject to certain exceptions. So, if something happens in your apartment that is normal wear and tear, something that is the landlord's responsibility, it is the landlord's responsibility to repair the unit. I know sometimes we might feel inclined like, oh, it's just, fix the toilet, I'll just take care of that myself. It is the landlord's responsibility to, as long as you aren't actively putting a hammer to the toilet, to intervene and provide repairs to things like that. So as far as tenant responsibilities, it's your responsibility to keep premises clean and sanitary as conditions permit, dispose of trash and garbage in a clean and sanitary manner, properly use all gas, electrical, and plumbing fixtures, not to commit or allow destruction of property by the tenant, family, or friends. This can be pretty important if you're having guests over, family over. You really want to be careful because if they damage the property, it can still affect you and your situation with your landlord. So make sure to, don't allow too many strangers into your apartment or people that you don't trust. Use the premises as a place to live and use rooms for their intended purposes. So, don't start maybe like a mechanic shop in your living room of your apartment, things like that. Other tenant responsibilities: repair all damages caused by the tenant's failure to use ordinary care. So if you do, you know, use a hammer on your counter, you might be responsible for repairing something like that. Um, Allow the landlord to enter to perform necessary or agreed upon repairs. The landlord usually has to give at least a 24-hour notice, written notice, unless there's an emergency, to enter your property. That's one that I think is worth noting, just because a landlord can't just walk into your apartment at any given time. You want to make sure that you're aware that they need to give a written notice that they're going to enter your property, at least a 24-hour notice. Remember, exercise ordinary care, and promptly notify the landlord if there are any problems. The landlord doesn't have a duty to repair if the tenant breaches their responsibilities, and that breach, has subsequently caused any sort of uninhabitable condition or interfered with the landlord's ability to do repairs. So you want to make sure that if there is a repair needed, that you coordinate with your landlord so that they can make that repair. You don't want to say, "Oh, I can't," you can't enter the property to make the repair if it is needed. Okay, so tenant remedies if landlords fail to do repairs. We sometimes hear about this, right? Not every landlord is a great landlord and not very good at kind of holding up their end of the bargain as far as keeping the unit in good order. So you can withhold rent, repair and deduct from future rent payment. You can abandon the lease, or you can seek legal counsel. This is all important to have some sort of record of any sort of communication with your property manager. So, before any of this even comes into your mind, you want to make sure that you've, notified with either through text or email of the needed repair. If they haven't gotten back to you, you've made several efforts to get in contact with them. You've basically put in a lot of effort, and you have documentation showing that you've put in that effort to ask for the repair. Because if something comes to, court, or you seek legal counsel, you want that documented evidence of, hey, I've reached out to my landlord 5 times about mold in my building. They haven't responded. They haven't done anything. Now is time for me to kind of seek legal action. Photo evidence is also good. So if there was like mold, you would want to take photos of the mold. Recommended steps for tenants to take. Again, notify the landlord of the problem in writing. Keep notifying the landlord if the attempted repairs are not successful. Take photographs. You can make complaints to local code enforcement and request an inspection. And you can file a lawsuit if landlords fail to promptly or effectively repair the conditions. So you have rights if something is broken or makes your apartment unlivable, and you've reached out to your landlord and they're not doing anything about it. You can take legal action. Retaliation is prohibited. So like if you were to complain to like a governmental agency or code enforcement about any sort of substandard conditions, living conditions, they can't take action against you, right? Just because you file some kind of complaint. I'll probably touch on it in a minute, but they can't ask you to move out because you've issued complaints. They can't discriminate against you or treat you poorly because you've made complaints, stuff like that. Termination of tenancy by the tenant. So basically moving out when you decide to move out. An early termination of a fixed term lease by the tenant is a breach of the lease, and the tenant may be responsible for contract damages. So if you have a 12-month lease and it's been 5 months and you're like, hey, I'm moving because of school or my mom needs help or something like that, you want to be aware of your lease agreement. You can address it with your property manager. You can say like, hey, I've got this situation. It looks like I might seek to move out early. Is it possible with a certain, 60 days notice that, we can make this work? Sometimes they'll have you pay like a flat fee for breaking the contract. Sometimes, they'll ask for more damages. So you want to be aware of that if you have a fixed lease agreement. Tenants can terminate a month-to-month agreement with a written 30-day notice of intent to move. So that's one of the benefits of a month-to-month lease agreement is, if you are changing schools in 3 months, you can live there for 2 months, submit a intent to move, live for another month, and then you can move to where you're planning on going to school. A tenant can also serve a 30-day notice of intent to move 30 days prior to the end of their fixed term lease. So 12-month lease, 11 months in, you'd submit a notice to move and be good to go. Once given, a tenant cannot unilaterally rescind. If you do feel like, actually the thing that I want to do fell through, communicate with the property, say, if this hasn't been put out on the market yet, or, maybe it's just easier to continue renting to me, I'd like to rescind that notice to move. So, there's still room to communicate with the landlord. Okay, a landlord termination of tenancy. So it requires a written notice, date, and reason given for the request to vacate. An exception to notice requirement is when a fixed term lease expires and the tenant holds over, or when it's an employee, not a tenant. So, if you have a fixed term lease, communicate with the property. If you want to continue living there, renew your lease, make sure that you give them a couple months heads up, just so that they're aware. And then if they have any intention of, renting to someone else, then you can at least get that heads up. Most leases say that upon expiration, the lease becomes month to month unless terminated. But again, that communication with the property is really helpful. So if you have a 12-month lease and you want to continue renting, many times it'll switch over to month, but talk to your landlord, because you don't want any surprises, and it's good for them to stay informed on what your plans are. The types of landlord termination notices: there's a 3-day pay rent or quit, a 3-day perform or quit, a 3-day quit, and then a 30 or 60-day notice to terminate tenancy, and then a 90-day notice to terminate. So I'll go through those really quickly. This can be served by personal service, substitute service, and mailing. Posting and mailing, like putting on your door and mailing you a letter. And then as far as how you count it, so once you get the letter, it's the day after you get the letter, or after the day after it's posted. And then if the notice ends on a weekend or a holiday, the tenant has until the next business day to comply. So yeah, service by mail is complete when it's deposited in the mail, not when the tenant receives it. That's a little tricky, but usually if you receive a 3-day notice, you have 3 days starting the next day. 3-day pay, rent, or quit notice can't be served until rent is late. Cannot demand rent for more than 12 months back. Must contain, your address, the amount due, the rental period, some idea of what the rent was from, forfeiture language, and then all the contact information of who to pay rent to. Must state usual days and weeks and hours of business for the person to receive rent if you're able to bring it in person. It can't demand additional amounts of rent unless it's characterized as an additional rent in the agreement. And if the terms are not met, then a 3-day notice to quit can be served. 3-day notice to perform or quit. This is more related to your actions. If you're very loud or breaching the lease in ways other than not paying rent, this is something that you can receive. It's used to compel performance changes other than the rent. Can demand payment for amounts due, such as late fees and utilities. So late fees and utilities aren't necessarily considered rent. So a perform or quit would be issued if you aren't paying your utilities, something like that. So if you're doing things that aren't prohibited by the lease, or are prohibited by the lease, you might receive a notice like this. And then if you needs aren't being met, then you can get a 3-day notice. And the 3-day notice to quit, it's usually if there's like a nuisance, illegal activity, if you're threatening the health or safety of others, committing waste damage that lowers the property value, or if you move in subtenants without permission. Things like that can give you a 3-day notice. A 30-day notice can be given if you've lived at the property for less than a year. And then if you've lived at the property for more than a year, you can get a 60-day notice to vacate. Yeah, and there should be language around how to make sure to move out properly, how if your property is left in the building, then how to properly reclaim it, things like that. And then a 90-day notice is usually reserved for government subsidized buildings, kind of like Section 8. So it require a much bigger notice, mostly because some of those Section 8 vouchers can be transferable, but it takes some time to get things in order. So that 90-day notice is for voucher holders. Unlawful detainers, aka evictions. So these are kind of where things really ramp up to the courts being involved. If a tenant does not voluntarily vacate, a landlord must file an unlawful detainer case and get court order to remove the tenant. Landlords are prohibited from using self-help, so they can't, get a big person to come throw you out of the property. They need to go through the court system and get like a sheriff to come and escort you out. The defendant generally has 5 calendar days after the service of summons to file a response. Trial usually is 30 days from the filing date. And then if you lose this case, it will likely affect your credit and your ability to rent in the future. So you really want to avoid an eviction at all costs because a landlord, as you apply to new units, if a landlord sees that you've been evicted in the past, that means that a previous landlord had to go through the entire process of going to court, reaching out to the court, paying for a lot of legal fees. And those are all things that a landlord typically doesn't want to see signs of. So it can make it really challenging to rent in the future. Common defenses to an unlawful detainer is they gave invalid notice, improper service of the notice, if the complaint was filed prematurely, the breach of implied warranty of habitability, acceptance of rent beyond the notice period, discrimination, or retaliation. So the acceptance of rent beyond the notice period, basically, you pay the maybe some amount due and they accept it and they still issue an eviction notice. If they're planning on serving you an eviction notice, they shouldn't have taken that money. Move out tips, request a pre-move out inspection in writing 2 weeks before move out. Attend in person, and keep an itemized list of damages. So remember, these move out tips are all supposed to try to protect you so that you get the most of your security deposit back. So leave the property in the same condition it was received in, except for normal wear and tear. Conduct the final move out inspection with the property, take photographs, and get a receipt for the keys and the move out date. And then we return to the security deposit. The refund or accounting for any amounts withheld is due 21 days after the tenant vacates, meaning that you should receive your security deposit amount back within 21 days. The landlord can withhold amounts to cover unpaid rent, damages other than normal wear and tear, and failure to return items such as the keys. They cannot charge for damages not itemized if the tenant requests the pre-move out inspection. And then the landlord must show receipts for repairs. And I think this one's important. So if if you move out and the landlord only gives you half of your security deposit and says, hey, I used that other half to pay for repairs, they also need to provide a receipt, a list of itemized list of expenses for those repairs. And then wrongful withholding of security deposit. If they don't give you your money back, the landlord cannot withhold the security deposit. Tenant can sue in small claims court to collect damages, the amount wrongfully withheld, plus twice the amount of the deposit in statutory situations. The landlord can counterclaim for amounts owed, so good to keep that in mind. And then it's important to have some additional resources. So California's Court Self-Help Guide, there's a link for that. And then the Legal Aid Society of San Diego, they come up with a lot of the language that was in this presentation. So it's always good to give them a call if you have housing related concerns that might reach kind of the need for legal assistance. So give them a call if you do have kind of those more personal situational questions. San Diego Volunteer Lawyer Program, the University of San Diego School of Law Legal Clinic. So those are all different resources that you can utilize if you have some kind of legal housing trouble. And thank you. Yeah, so there's the presentation. I know we covered a lot, but I think it's good to kind of have that foundational knowledge of your rights as a tenant.